All right, the second case on our docket this afternoon is 20-50769, Redding versus Stanton. Ms. Cogliano, I hope I pronounced your name correctly.
Yes, Judge, you did actually. Thank you for that. Chief Judge Owen and Judge Higginson and Judge Clement, I really appreciate you guys giving us the time to argue in front of you today, because I know you've heard similar facts and similar cases and arguments a lot. And given that—
Just for clarity, were the lawyers who were just added to this Zoom proceeding, were you all able to hear the arguments in the case that we just heard?
Yes, ma'am.
Okay. So okay. All right. Thank you. For clarity. All right. Thank you.
Yes, and I'm prepared to address some of the things that I think are going to be important in both cases. But I want to take a second to remind everybody that, these are big numbers of people, but each one of these people are actual people. They're not just numbers. We have 3 clients, all of which we've alleged in our complaint were not a member of either of the biker gangs that were involved in the shootout. We know which biker gangs they were a part of, clubs, that they were a part of, and neither of them were a part of the Cossacks or the Bandidos when they were at Twin Peaks that night. They were, in fact, though, men that had families, that had jobs, one of which had a birthday the next day. And this really impacted their lives, their families, and their bank accounts. And on that note, I want to address some of the factual issues that I think distinguish us a little from the other case, but also make us similar. One of those facts is that one of the facts that distinguish us that you guys discussed is that we did affirmatively plead that none of our clients were involved in either of those biker gangs, had any connection to them in any way, and were not involved in any criminal activity that day.
Ms. Cogliano, the strange thing, which your brief points out, is that the Chavez affidavit didn't allege that your clients were affiliated with them. It just doesn't seem to get there at all, which is why I asked so many questions about Mallett.
Correct, Judge, and I will address that briefly here with you. Ms. Kadirhan is set to address almost entirely the independent intermediary doctrine and all of that. But I do agree with you that as far as our clients go, the PC affidavit really doesn't say anything at all about that.
Well, I'm sorry, what's the blueprint? If you're not dealing with the independent intermediary doctrine, what are you talking to us about?
So I'm going to address some of the factual discrepancies that have come up between our pleadings and the defendant's pleadings, as well as the Fifth Amendment claim that is unique to our specific case here, which we have alleged that there was also, along with the Fourth Amendment violations, a First Amendment violation that impeded our client's right to assemble.
This is the First Amendment argument. This is not the Cole substantive due process argument. You're going to talk about the
First Amendment, Judge. Correct. And what I'd like to point out with the First Amendment claims is that the only paragraph in the probable cause affidavits that say anything about any of the suspects that were being arrested is the paragraph that says, after the altercation, the subject was apprehended while wearing common identifying distinctive signs or symbols. And that clearly implicates the First Amendment, because it's very clearly established law all the way back from the 1960s that even if you are associated with a group that does engage in criminal conduct, just your association with them, just the fact that you're wearing the same colors as them is not at all enough to give you the liability as being part of a group. There has to be some other conduct, knowledge, intent, affirmative act to show that you are purposefully engaging in the criminal activity that's alleged to have occurred with that group. And here, first of all, I'd like to point out that none of our clients were wearing the colors that are the same. They were not wearing the patch that is specifically identified as being the patch associated with the Bandidos or with the Cossacks. But even if they were, judges, that still does not give liability to them without some affirmative act that has not been alleged in any of the pleadings, at all. In fact, Defendant Reyna provided us and the court with a huge summary from a different federal case of all of the war between the Cossacks and the Bandidos, and our clients are not mentioned anywhere, and our clients' affiliated clubs are not mentioned anywhere in all of that.
But aren't you sort of arguing yourself out of being able to argue a Frank's taint? If they made no allegations that incriminate, they clearly didn't make a false incriminating allegation.
Judge, my argument for that is it has to be one or the other. Either the probable cause affidavit does allege that our clients, or insinuate that our clients are involved with one of these gangs, and if that insinuation is what this court thinks is good enough to establish probable cause, then that insinuation is false and should be analyzed under Frank's doctrine. But if this court agrees with me that this probable cause affidavit does not establish anything about our clients, then it wouldn't be a Frank's analysis. And so I think we've got to pick one or the other. And I think I'm very confident that we survive both of these analyses.
Well, let's say we pick the one where there's no PC in the affidavit.
Yes.
What's the case that says that a subsequent grand jury couldn't cure that Malley violation? Because if there isn't enough evidence from someone like Chavez, why wouldn't we assume other witnesses are put in the grand jury? In other words, you can see I'm struggling with the misfit between Malley and independent intermediary when it's a grand jury over 2 days, because I stood corrected. Presumably, if Chavez didn't give the evidence, maybe another witness did.
Sure. Judge, I want to again reiterate to you that Ms. Kadirhan has very much prepared this issue.
Okay, you keep going then. You're right. Go ahead. You keep going with your argument.
I just don't want to speculate.
No, you're right. You're right. I keep slipping into it. Go ahead.
So as I pointed out, since 1961, the case law on the First Amendment has established that you cannot be held liable for simply associating with a different group. And I think it's unreasonable to assume that that is not clearly established law. But I would also like to point out here that under the qualified immunity doctrine, the Supreme Court of the United States has ruled recently that in circumstances that are so obscene, so beyond the scope of anything we've seen before, that even if there's not a case on point, it's clearly beyond the scope of anything that's reasonable, and no reasonable officer should think that it was appropriate. And here we have hundreds of PC affidavits arresting hundreds of people with not even an attempt at any particularized finding at any of those individuals. And then all of those individuals are held on a $1 million bond. And that is so beyond the scope of any mass arrest, any lack of particularized finding for mass arrest that's ever occurred. And I think it's unreasonable to assume that a law enforcement officer wouldn't realize that, especially considering, as we've alleged factually in our complaints, that several law enforcement officers declined to sign the complaint. They did not want to be the one to sign the affidavit supporting the request for the warrants in this case. And so clearly most reasonable officers on the scene did not think that this was appropriate, and yet didn't do anything about it, and so should still be held liable for the fact that this tragedy occurred to hundreds of people that simply wanted to gather and learn about legislation that was going to be affecting them every day. And what's important to that I want to point out, we've also alleged as a factual allegation in our complaint, is that everybody knew this. District Attorney Reyna knew that the coalition was a peaceful organization because he'd worked with them before. The other law enforcement officers.
Now your time has expired. You saved some time.
I apologize, Judge. Thank you for your time. I will pass the computer over to Deniz.
Good afternoon, judges. I wanted to jump right into Judge Higginson's question about how do you resolve Malley versus the independent intermediary doctrine. So this court's decision in hand, which is the decision that established the intermediate or IID, said, quote, any misdirection of the intermediary by either omission or commission perpetuates the taint of the original official behavior. And so if this court decides that there's no probable cause And so then that would go to the Malley violation rather than the Franks violation. The fact that there were material facts that were withheld from the intermediary would still show that there is taint, and therefore IID would not absolve the defendants of liability in this case. So I think that that's important, because I know that Judge Higginson, you've had some questions in the previous argument as well about that.
I guess that's, if you have a case, that would be also illuminating, because my understanding of a Malley violation is you just never got there. It was facially defective. So you didn't withhold anything. You told the court everything. It just doesn't equal PC. So there's no omitting an exculpatory fact.
Well, Judge,
there's no false statement. There's no omitting. I'm curious whether or not, obviously a Malley violation stands alone. So it's not as if a grand jury can cure it. It's a difficult thing. Do you have any case law on this topic? Almost every independent intermediate case I see is a Franks violation.
I agree with you, Judge, on the case law. However, Malley itself talks about being so lacking in the probable cause affidavit being so lacking in probable cause, so as to render official belief in existence unreasonable. And so if that's the case, if the PC affidavit does not have probable cause, then that is obviously a Malley violation, but I don't think that that is at odds with the independent intermediary doctrine, which states that you did not put material information into the PC affidavit. And so I don't think that those are in conflict.
Okay, keep going.
Okay, so I also wanted to talk about some of the differences between our allegations versus allegations in the other cases that would lend to showing that the taint was carried throughout the case. And so for the original arrest warrants, the taint there was when all of the defendants together, Reyna, Stroman, and all of them got together to discuss what was going to be put into the affidavits. And then they all agreed what would be put into the affidavits. And then that's the taint that moved forward there. Just as in McLean, we alleged three things, the same three things that this court found to be sufficient in McLean.
How did that get carried forward to the grand jury?
In the grand jury, we allege in this case that that defendant Reyna had a pattern and practice of both withholding relevant information that exonerated our clients and also put out false narratives. So, for example, Reyna promised Rogers, who is the officer who originally met with the confidential informant in this case, Reyna promised him that he would never see the inside of a courtroom because he would hide that offense report from the criminal defendants. And then he actually did so. He repeatedly refused to disclose that offense report, despite Texas law requiring him to do so, and despite multiple requests for him to do so. He also refused to provide video where Reyna met with the confidential informant. He just withheld that information up until there was, in the middle of a trial, the judge ordered him to do so. He also refused to provide the written plan of action created in anticipation of the coalition meeting in 2015. He also encouraged the Texas Rangers law enforcement officers to withhold exculpatory evidence from the discovery from the defendants, the criminal defendants. And he coordinated with others to prevent criminal defense attorneys from receiving records and cell phones through subpoenas that would have been exculpatory in these cases. So that is a pattern that shows that he had a practice and intent and a plan of withholding information. He also had a pattern and practice of putting out false information. And so Defendant Reyna and Defendant Swanton went on a media tour putting out false information about what happened in the case that they knew was completely false. And so This pattern by defendant Reyna shows that throughout the case, he was hiding relevant information and he was also putting out false information. And so there's no reason to think that that pattern would have stopped inside of the grand jury room. We know that he affirmatively chose not to have any.
Okay, if you put this case in front of a jury, can they draw the reasonable inference that the grand jury did, in fact, that was what happened in the grand jury?
I think that if we put out these facts, the jury absolutely could conclude that that's exactly what Reyna did, was that he just kind of boilerplate put out 106 indictments in 1 or 2 days. And there was no time for them to actually dive into the evidence, and he didn't, in fact, show any extra evidence. Additionally, this is what discovery is for. This motion is premature. We need to have the discovery phase so that we are able to get other witness, gather additional discovery so that we could prove additional information to a jury. But we're just—
Is it undisputed that the McLennan grand jury transcripts don't exist?
As far as I'm aware, it's undisputed. I haven't heard anything otherwise from the defendants in this case. But again, on this motion, we are moving forward on the belief that everything in our complaint and all reasonable inferences are true.
Oh, in every Iqbal Twombly case, you say the defendant acted with fraud or fraudulent intent, and that's all you say. And the argument is, well, if I can just get discovery, Your Honor, we can prove it. Well, that's clearly the sort of conclusory allegation that doesn't get you there.
Well, Judge, in this case, we have alleged a multitude of facts showing that Reyna had this intent, practice, and pattern throughout the length of the pendency of the case. And so there's nothing to show that he did something different inside of the grand jury. And so based on the standard that we're at right now, 12b-6, we have alleged all of this, and that inference is more than reasonable to get to from what we've shown. And I see that my time is out.
All right, thank you. Mr. Brandt?
Chief Judge Owen, Judge Clement, Judge Higginson, may it please the court, Tom Brandt for Abel Reyna, former DA of McLennan County. The appellants in this case, as opposed to the Wilson plaintiffs, the appellants here have given up on the notion that they have to adequately plead taint. Instead, they take the position they don't have to adequately plead it at all. They say that they don't have to address it. It's the burden, they say, is on the defendants to prove that there was no taint.
And that's squarely rebutted by Macklin, right?
Exactly. I mean, and it's absurd to suggest that we would be able to prove a negative anyway. How would we prove something didn't happen? How would you go about that particularly? But anyway, they're simply wrong. Abel Reyna is entitled to qualified immunity in this case. First of all, this is a Fourth Amendment case. I know they've thrown in First Amendment, but it's a Fourth Amendment case, really. And he didn't arrest anyone. He didn't cause anyone to be arrested. We know that. It's in the record. It was the theory of the plaintiff is that Reyna established this theory about, hey, you can use the engaging statute, and if you arrest people on that, I'll prosecute them. Okay. He set out criteria, and then the criteria was followed by law enforcement. Stroman.
That's an issue that's in Terwilliger, though, right? So you're arguing that we would hold for that court?
Well, I think it would be appropriate to hold for that court. That's fine. It makes sense to me, but you all will do what you need to do. But the underlying issues about probable cause and Franks and all that are addressed directly in Terwilliger. So yes, it might make sense to do that. But he didn't arrest anyone. He didn't cause anyone to be arrested, and that's undisputed. Chief Stroman testified under oath that in some of the criminal cases that he was the one who made the decision about probable cause existing, and he was the one who said, yes, we're going to arrest these people. So there is no Fourth Amendment claim that can be made against Reyna. And I think that when you're talking about probable cause in general, you also the approach that the plaintiffs take is to use an improper understanding of probable cause and in multi-suspect cases. In this situation, it was overwhelming how many people were involved, how many people were killed at the scene. 9 people dead, many others, a dozen or more wounded, hospitalized. This was absolute mayhem.
Mr. Brandt, how many people were convicted of those shootings?
None. But the question isn't guilt or innocence, or whether we can prove guilt or innocence. Of course, the issue is qualified immunity, probable cause, arguable probable cause, and whether or not there's a Malley or Frank's claim involved. But they give up on that. The Redding plaintiffs, they've just given up entirely and said, no, it's your burden, and that's wrong. So I don't see that this court needs to delay in this particular appeal to wait on the Terwilliger cases. They've pled themselves out. The independent intermediary doctrine does bar this. And I think in answer, Judge Higginson, to some of your previous questions about the Malley and the grand jury, those are separate items in a sense, because if probable cause exists as a matter of fact, if the probable cause affidavit was insufficient under Malley, probable cause can still exist as a matter of fact in truth. And that truth is what can be presented later at examining trials and at the grand jury. So you can easily reconcile the fact that there might be a Malley's claim, and it can be cured by a grand jury because, as you mentioned, you have to presume some level of good faith in the grand jury process, and you certainly have to do that in the examining trial process, which was open to the defendants. And the reason they stopped doing the examining trials was because they were losing. Probable cause was being established. And also, it's interesting to note that counsel for the plaintiffs in this case was complaining about all of these so-called horrible things that Abel Reyna was doing. She's talking about the criminal prosecution and the discovery that took place there. There was a mountain of discovery that went on in the criminal cases themselves. They found out all kinds of things. And, that may be part of the reason why no one was ultimately prosecuted and convicted, perhaps. But the fact of the matter is, you can't say, oh, we need more discovery when you've had a mountain of discovery through the whole process in the criminal courts. And then complain that this shows that, we found out all this stuff, and this shows that there must have been taint, when we're not even willing to plead any factual allegations about taint. And we're just going to kind of broad brush it and say, oh, well, he's got a policy customer practice of being a bad guy. And despite the fact that he didn't arrest anybody, didn't cause anyone to be arrested.
What evidence was there presented about what happened in the grand jury, in the federal proceeding? You said there was a whole mountain. There was the mountain of evidence I'm talking about. I hear you, but I'm saying none of that went to what happened in the grand jury room, right? Right.
That's correct. But the notion that we should not deal with this on a motion to dismiss. We should go through full-blown discovery because we need discovery on all this. That's what I'm pushing back against. I mean, they've got to plead something that is a fact. And what I hear them saying was, well, we're really not sure. We're not going to plead that. We don't know if it's a Malley.
The case relied on by the district court was Curtis, where the only allegation was that the DA in his head might have known they were innocent.
Yes, and that means that we win. That means Reyna wins.
No, but I mean, the reason the law says there's a very low bar as to taint at the motion to dismiss stage is because of case law, Macklin, because it would then be impossible for a hypothetical plaintiff to ever show it since it's secret. And it could lead to a situation where an officer could lie, and then it gets cleansed by being thrown into a grand jury. So it seems you may be right in the end when we find out a little more about what was given to the grand jury, that other people filled in the rest of the PC. But I don't see the law that says you can just decide that now.
Your Honor, my time is up. May I answer that question, Your Honor?
Yes.
Okay. The premise of your question, I think, is flawed, Your Honor, with all due respect, because under Twombly and Iqbal, they're required to plead facts. Okay, so I don't think the bar is as you suggested it is. I don't think it's so low on the taint. I think it's a Twombly-Iqbal standard for pleading specific facts of taint. And it ought to be that way, because if we run a
Right,
system,
but their fact, you heard her say, their fact alleged is that you knew from video evidence that they weren't even members of the Bandidos or the Casas. And you didn't present to the grand jury because you wanted to arrest everyone. That's what they've pled. How can you get more specific than that?
that's not material that they're not a member of the Bandidos or Cossacks. If they are part of one of the support clubs, then they have patches, they have colors, they're present there. It's not required that we prove that they were a member of the Bandidos or the Cossacks. If they were part of the COC&I, and the evidence that was presented in the examining trials was that this was a support system, and a farm system for the Bandidos. The Cossacks came uninvited to the farm group of the Bandidos because, as you well know from U.S. versus Portillo, a war had been declared and was raging long before the battle at Twin Peaks. So we know there was a war going on. We know it had a structure. We know it had, and you know from other cases you've dealt with, that the structure goes, there's pinnacles of the top is Bandidos and the other is Cossacks. Below, everybody falls into, and they work their way up the system to get into the big leagues of the Bandidos and Cossacks. So that's what we know. So it's not enough for them to say, well, we think you knew that we weren't part of the Bandidos or Cossacks. That's absurd. We had plenty of intel saying this organization is a farm system for the Bandidos. And if you're there, you're not there for a good reason. You can say you're a Boy Scout trying to learn about legislation, but that doesn't have to be believed by law enforcement.
All right, thank you, Mr. Brandt. Mr. Mackenzie?
Yes, Your Honor. May it please the court.
Excuse me.
Here.
Chief Judge Owen, before you begin, one of the appellant's camera turned off, and I am not sure if they're still there.
Let's pause and make sure they're there.
Okay, there they are. Just keep your camera on, okay? Thank you.
May it please the court. Alfred Mackenzie, again, on behalf of the city appellees, but I did want to note the city is not a party in this case, so there's no municipal liability issue. Instead, there are only 4 individual city appellees in this case. But I also want to go back to something Ms. Cogliano said, and I would point the court back to the pleadings. As in the Wilson case, where there are about a dozen complaints, in this case, there are actually 5 complaints involving 3 plaintiffs. And I would challenge the court to find a place in the complaints where they actually say, we were not members of the Bandidos or the Cossacks or its affiliates. They don't do that. They deny in a conclusory fashion, as has been consistent throughout all these cases, being members of a criminal street gang. Only 2 of the plaintiffs in this case say that they were members of the Escondidos, which a reasonable law enforcement officer can take judicial notice, not judicial notice, if they would know that that's a support group of the Bandidos. So that they have pled affiliation because that's imperative to their First Amendment claim. They don't say anything about the third, and they certainly don't deny he's a Bandido because they can't. With regard to the allegations of conspiracy, I would point the court back to Portillo, where the court said agreement, guilty knowledge, and participation in conspiracy, which is the same thing required under the engaging in criminal activity statute, conspiracy to commit one of the underlying offenses, may be inferred from the development and correlation of circumstances, including defendants' presence and association with other members of the conspiracy. What the plaintiffs have failed to plead are any facts that say they were not associated with the warring parties at this gunfight. They simply conclusory deny being members of a criminal street gang. They never say Escondidos were not affiliated with the Bandidos. They could have done that had they believed it to be true. They don't plead the facts that are necessary to raise an inference of taint. And so we get to the grand jury where it's secret, and we can't invade the province of the grand jury because Reberg, the Supreme Court, tells us the witness testimony, if there was any, is immune, absolute immunity, and that testimony can't be used in support of a plaintiff's 1983 cause of action. So when the plaintiffs plead that Chavez likely testified, speculation, we don't know if he did or didn't, then that can't be used as a basis for a taint, they have to have some independent evidence. Look at Winfrey. What was the independent evidence? Before the case goes to the grand jury, it was already publicly known that Pickett, the canine officer's scent methods had fallen into disrepute. It came out at the criminal trial that the jailhouse snitch recanted his testimony and said the sheriff was trying to make something up. All this was available to be pled. So you don't have to invade the province of the grand jury's secrecy, even if in the rare instance that might be possible, to allege a taint claim if you have one. In this case, though, as Mr. Brandt pointed out, the plaintiffs have given up on that and are simply saying it's an affirmative defense. And here Judge Albright rightly relied upon Judge Sam Sparks' opinion that it is not an affirmative defense. And if we look at all the cases this court has dealt with, including McClellan and Curtis and Shaw, taint has to be affirmatively pleaded. And with regard to taint, this deals with some of the particular individual city officers, where what we heard today, the plaintiffs are arguing that some of the officers didn't believe the plaintiffs were guilty. But Curtis says that they are, they said that it was insufficient to allege that the district attorney persuaded the grand jury to indict the plaintiff and others, even though the district attorney knew there was no factual legal basis for doing so. So even if individual officers had a question about the legal basis for finding probable cause on this statute, that subjective belief is not sufficient to show taint. You have to couple malicious intent with a misrepresentation or a material omission. And it has to be specific to each defendant. And here, going back to Judge Higginson's question about, well, if one defendant testifies maliciously and misrepresents the facts to the grand jury, doesn't that taint the entire process? But in this case, remember, there's no allegation that the 8 individual defendants arrested the plaintiffs. The allegation is that they somehow participated in the process that made it flawed. So the only claim they could have against an individual defendant is not that they wrongfully arrested because the probable cause was absent due to some taint at the grand jury. They had already been arrested. The only complaint could be an individual defendant did something wrong. And in a taint situation, that has to be maliciously withholding material information or presenting relevant misrepresentations to the grand jury. They have no pleadings that any individual.
You don't disagree with Texas's statement of what the malice scienter is, though, which is it's just knowing or reckless disregard. You agree with that?
Well, the court has done it both ways, so I think they're basically the same. So what we tend to see is in the warrant situation, the language is intentional or reckless disregard for the truth. And we tend to see in the grand jury situation that there is a malicious intent to withhold or misrepresent.
I couldn't find a single taint case where a court said the taint doesn't exist because the scienter isn't there. Do you have one?
I don't think they ever. I don't think they ever actually turn on those facts. No, Judge.
Right. The district court here didn't say that's what you didn't allege. The district court said you didn't allege a false statement with particularity, right? So it didn't turn on the sort of slightly difficult and nebulous issue of scienter that I read.
I believe that's correct, Your Honor. And so what are the facts that the plaintiff claims to be either omissions or misrepresentations? They're all conclusions. They deny they were guilty. They deny the significance of showing up at a gunfight wearing the colors of a motorcycle club that a reasonable officer could believe was associated with a criminal street gang. And that's where clearly established law comes in. There's no clearly established law that a reasonable officer couldn't conclude that if you show up at this type of activity wearing the colors of what they associate with the criminal street gang, that they're probably guilty of engaging in organized criminal activity.
Thank you, Mr. Mackenzie. Ms. Cogliano, you've saved some time for rebuttal. And Ms. Englehart, would you add 3 minutes to her rebuttal? I'm sorry, Mr. Wilson.
Right.
Mr. Wilson is next.
Yes, Your Honor. Thank you. May it please the court, Ben Wilson for Agent Schwartz and Frost. I'd like to really quickly begin by establishing, I think, that this is a Fourth Amendment case, not a First Amendment case. That's consistent with what this court held in Mayfield v. Curry, if you look at note 1, where it discusses a complaint with similar allegations raising First Amendment, Fourth Amendment, et cetera, claims. And the court really clearly says that this is a Fourth Amendment case. It's the most specific. And that fits well with the Supreme Court's recent opinion in Nieves v. Bartlett, which Mayfield cites. Because if you have an arrest and a First Amendment claim that comes out of that, where there's probable cause, you're generally not going to have a First Amendment violation. That's what the Supreme Court says. Really quickly, then, I'd like to turn to the 2 grounds that I think are dispositive for Agent Schwartz and Frost. First, like in the last case, we think there's a fundamental Twombly-Iqbal problem. Plaintiff's allegations specifically against Agent Schwartz and Frost are really threadbare. They allege that they were aware that violence might erupt at Twin Peaks. They allege that they saw the gunfire and the melee erupt. And then they say in the blue brief that they prevented the probable cause affidavit, that they failed to prevent the probable cause affidavit from being presented to the magistrate. Under either a Franks or Malley claim, that's not enough. As this court's opinion in Melton makes clear, liability in Franks does not extend to the officer who neither prepared nor presented the warrant affidavit. They don't explain if Agent Schwartz and Frost presented facts or what those facts were. So I think that's enough if the court construes it as a Franks claim. The Malley claim fails for the same reason. Under this court's opinion in Machellick, liability extends to the affiant, but also to an officer who prepared the affidavit, sort of knowing all of the circumstances. They certainly don't allege that Agent Schwartz or Frost did that. In fact, their allegations are contrary to that. They say that Agent Chavez executed the mass arrest warrant at Rayna's direction, and that Stroman adopted Rayna's plan to conduct the mass arrest. So Agent Schwartz and Frost—
Of course, the district court here didn't parse it by defendant. So Melton and the causation levels and proof, that hasn't been done by the district court. I hear you're probably asking us to be able to affirm as to your 2 clients on that basis if we chose to.
I think that's right, Your Honor. I think more fundamentally under Twombly and Iqbal, for every defendant in the case, they have to have adequate allegations.
And what would help me would be, tell me what would be enough for a hypothetical plaintiff here to get past Iqbal Twombly as to the grand jury. What do you think they'd have to know about that black box?
Your Honor, I think it's hard to say hypothetically.
It can't be an impossibility. Even the district court here said this isn't the taint doctrine isn't in the grand jury context never available. And so I would have thought when they say, well, you omitted exculpatory video evidence that saw that my guy was with a different gang and he was 100 yards away and he was ducking, that's getting past the motion to dismiss stage. Or when you lie and say my guy's affiliated or associated or part of the Bandidos Caustics, I'm not saying in the end it'll prove that that was a lie, but if you said it and they deny it, there you got a straightforward Franks problem. Wouldn't those be enough at the motion to dismiss stage?
To be clear, I don't think they actually say that either Schwartz or Frost did it. I don't think they have allegations in their complaint against Schwartz or Frost as to either.
I know, but that's coming back to parsing defendants. You were saying as to no defendant here. You said, so I'm just trying to think, how would you ever have a taint doctrine? None of you have been able to tell me what a hypothetical plaintiff would have to allege because they don't know what happened.
Your Honor, I think what we see in some of these cases, and maybe the Shaw case is the best example. You have to have at least enough facts extraneous to show that there's a reasonable inference of taint. I mean, that's the bottom line pleading obligation, I believe, is under Twombly and Iqbal is to show plausible allegations of taint. I think I'd like to turn to the other reason that we think the judgment below should be affirmed, which is Officer Schwartz and Frost are entitled to qualified immunity in this case. This court, in its en banc opinion in Melton, dealt with exactly the standards for both Frank's and Maui claims. And it's a little confusing because the court is sort of harmonizing the two lines of cases. What I would direct the court to is Judge Costa's concurrence, where he talks about the Hampton case and how the Michalik standard had gotten into Maui claims. The point is that Melton, of course, is a 2017 case, and these events occurred in 2015. So we think it's really quite clear to establish that the clearly established law for either a Franks or Maui claim in 2015, when these events took place, was Hampton, which is importing the Michalik standard into Maui claims, and that means that we're easily entitled to qualified immunity. Judge, I see my time has expired.
Thank you, Ms. Cogliano. Ms. Engelhardt, would you add 3 minutes to hers? Thank you.
Thank you, Judge. I hope I'm not too disjointed here. I'm going to try and address some of these things and jump around a little bit. I'd like to just quickly address the argument that probable cause defeats any First Amendment claim. I agree with that. That is the standard. Our allegation here is that there is no probable cause, and so it doesn't defeat the First Amendment claim because they clearly didn't establish probable cause in the PC affidavit, either through, whether you think it through Frank's or Maui analysis. As far as the allegations of taint, I think I would just reiterate what Judge Higginson has said a couple of times today, which is, you know, we've done our best. We weren't provided much. We weren't provided much discovery. That was precluded from most of the defendants in the underlying case, in the criminal case. We weren't provided any particularized fact in the PC affidavit. We have alleged specific reasons that we think infer taint, and that is sufficient because we are not privy to the grand jury proceedings. We cannot get that information at this stage. We're trying to get there and hopefully file that motion. But what we have done is shown why we think there's taint. We've specific facts as far as Reina's history, what his motives were. He was trying to get a book deal surrounding this whole event. He was talking to the media about this whole event. And that shows that his intent to not be entirely truthful about the facts of this case.
Well, clearly the affidavit did tell the magistrate, and therefore inferentially the grand jury, that your clients were members of the warring gangs. And one opposing counsel a minute ago said it is not true that in your complaint you deny that. Can you elucidate that?
Yes. As far as Mr. Landers, Reina we alleged in our complaint that District Attorney Reina had communications with him before about prosecutions, knew he was involved in the Escondidos Club. The Escondido Club is a limited liability corporation. They are not listed as a criminal organization. And importantly, they own concealed handgun licenses, which was known by DPS at the time, which they're precluded from owning if they're known to be a part of a criminal organization, a criminal street gang. It's the same standard as it is when you're defining a criminal street gang under the engaging in organized criminal activity. On top of that, Judge, I don't have enough personal experience with biker gangs to say whether there's many in multiple clubs or not. But what I would say is we did allege which club our client was in, and there's no allegation anywhere in any part of this that he was a member of two clubs or that he was a part of the Bandidos. And I'd like to really stress that it was suggested that the court take judicial notice that the Escondidos is a support group for the Bandidos. First of all, in the federal case of Portillo, where Portillo was a main guy in the Bandidos, it goes through a number of the support clubs for the Bandidos, and the Escondidos is never mentioned in any of those pleadings or any of those documents either. So I'm not sure where judicial notice would be taken of that fact in the first place. I'd also like to address the idea that the coalition of clubs and independent bikers has any known criminal activity. In fact, it's known by many of the defendants the opposite. They are a legal lobbyist organization. They have meetings all around the state. They were involved with District Attorney Reina when he was prosecuting somebody that killed a biker gang. They were involved with some other defendants when they created Motorcycle Safety Awareness Month that very month that this occurred. And so the idea that this coalition is some known criminal enterprise, it is really just coming out of nowhere. I'd also like to reiterate that not only did we plead which club we are associated with, we also pled facts as to the behavior of our clients when this occurred. All of our clients ran, and they even ran further than some of the people that were in the church-related clubs or in veteran-related clubs. None of them pulled a weapon out or shot a weapon, and this is all on video and was visibly observed by law enforcement that were on scene for the purpose of watching this. And so I certainly don't want to insinuate in any way that our clients were involved with the Banditos, but I'd like to remind you that that in and of itself is not enough. It may be used as one fact, but there's no other fact here that any of our clients ever had a criminal intent, criminal knowledge, or criminal act in any way. There's no mens rea and there's no actus reus that's alleged in any document that has occurred. And this allegation that we are only using conclusory statements, when you look at how our clients were arrested and held on $1 million bond for several weeks, losing their jobs, missing their birthday with their 17 grandchildren, based on an entire PC affidavit that doesn't say a single actual fact about a single person that was arrested. When they have all the information, we're here trying, our hardest to fight this power that has all the information. And I'm confident that we have alleged everything we need to get to discovery. And the point of discovery is for us all, the court, the parties, the actual lawyers, to know more. We're trying to know more so that we can know if there was a constitutional violation or not. And finally, I'd like to discuss the fact that this was mayhem, right? People were killed, people were injured. Unfortunately, that was the fault of the defendants in this case. They knew something was going to go down. They didn't tell a soul. They watched as this occurred, and then they arrested everybody else for it occurring. If they had created particularized probable cause affidavits, only the individuals responsible for the criminal activity would have been arrested, and then those prosecutions could have been successful. And it's really unfortunate that we have a city now that's exposed to some liability, and that we have, individuals that have been killed without any justice, and someone needs to be held accountable for that. And in this circumstance, it's the defendants in this case. That's all I have.
Thank you. We have your arguments. We appreciate your careful attention to the details of this case. Thank you. That will conclude the arguments this afternoon. This panel will convene at 1 o'clock tomorrow afternoon.